Hi guys, it's Kathy. I hope you're doing well. We made it to Sunday late, but we're here. Fozzie called me and woke me up, which is stupid because as soon as I got off work, I tried. I tried so hard to go to sleep, and my feet really hurt. So every time I fell asleep, I was dreamt that I was still at the restaurant serving, and my feet hurt, and I wasn't allowed to sit down. And my feet would wake me up, and I would toss and turn. I could not sleep, and I think an hour ago I fell asleep. Isn't that stupid? That's stupid. Fozzie, thank you for calling me. I appreciate it. I do. I do. Okay, I can't. I think we're back into another. I think we're going into a different um, lawsuit, but I can't 100% remember because we missed a day. So I can't remember that far back. So let's go. Let's look and see.
Good morning, I'm Craig Novak, McDonald, defense registry. Once again, I want to object to the presence of the cameras in the courtroom. If I may be heard as the cameras.
Go ahead.
Yesterday, at about this time, we were at Judge Silva over District Court 9. The same film crew was present in that courtroom. Judge Silva specifically directed the cameraman on Monday, Mr. Falcone, not to air or show any of the proceedings. She reasoned as simply as you did that the word media has to be adjusted with the changing technologies. I concede it's a good, valid point. Having said that, the judge instructed Mr. Falcone not to air the opening statements until the witnesses had been on the witness stand. By mechanisms that's still not completely known, two of the three witnesses were showing the arguments of opening statements. They didn't volunteer to come down at about 10 o'clock on Monday evening to help the prosecutors with additional evidence. Judge Silva declared a mistrial as a result of the cameraman's violating the court order. We have another hearing today at 1:30 for Mr. McDonald's custody status, and I will be filing a motion again to change the mistrial from without prejudice to with prejudice. It is against that background I feel compelled to ask for continuation of this sentencing. I'm going to ask Mr. McDonald to be given an owner cognizance release. We're going to ask for an appointment of an investigator and investigate whether there was contamination of this particular trial through the mechanism of this courtroom or through these cameras. I have complained, and I candidly am tired of hearing myself having to say this, but the record has to be made. These have been the most extraordinary proceedings I have been party to as a criminal defense lawyer in going on 30 years now. This is the first time I've seen a detective get on the witness stand and say something that I know is specifically not true. This was the first time I had a detective get on the witness stand and say, I found the investigation, the allegations were not true, but I continued to investigate the defendant anyway. This is the first time in my life I've seen the state attempt to
Counsel, what is that? I allowed you to have your hearing regarding the cameras. As far as the sentencing, then we need to start that.
Okay, thank you, Judge. I believe that these proceedings have been contaminated by the presence of these cameras, these courtrooms. There are cameras in the courtroom based on the facts as they were reduced in Department 9. I believe it's the ends of justice warrant releasing Mr. McDonald, sentencing a new sentencing date, and giving me an opportunity to investigate, and I may have to petition the court for appointment of an investigator. But this verdict has been contaminated, and I believe through improper exposure of the courtroom testimony to the witnesses, and certainly to a reasonable inference, and it needs to be investigated.
But you have no evidence of that, just because in another case over almost 90 days ago, I believe, is when we did our trial.
Yesterday?
No.
Okay.
That case was whatever. But you have no information at all regarding our case, correct?
I stood on a courtroom Monday and watched Judge Silva tell a man not to do something, and then saw him go out and do it directly, contaminating the verdict. That was yesterday.
State.
And, Your Honor, obviously the state would oppose any continuation of the sentencing. Anything that occurred in the other case in front of Judge Silva has no bearing on this sentencing going forward and is not a basis for continuing the sentencing. And I'll just briefly correct the record. The same organization was filming the trial that was in Department 9. After opening statements were concluded, defense counsel did make the request that the video of opening statements not be posted until the trial was completed. Judge Silva granted that request. The organization did not inform Judge Silva that the opening statements had been live streamed. The state was unaware that 2 of its witnesses had actually watched opening statements. And none of the witnesses volunteered to come down at 10 o'clock at night and help the state. One of those witnesses did then email some information and some evidence to my co-counsel, which was relevant to the case, and we provided that to Mr. Mueller. But due to that being a late disclosure of evidence, that was the basis for the mistrial being granted. Judge Silva specifically stated she was not granting the mistrial on the basis of the cameras. It was on the basis of information that had been provided at a late date. Additionally, there is simply no basis for continuing the sentencing in this case on this basis. And I wanted to also note the motion which defense counsel filed. I was not served with it at all, but I did review it. Candace Ruiz was not a witness in this case. He stated that she was the main witness in this case and is one of the witnesses involved. The witnesses involved who watched the opening statements in the other case did not testify in this case.
Look. Do you see this big stack of paper she has there? I'm sure it's not. But she said the motion that he just filed, and she touched that big stack right there. Could you imagine if that was his motion? Hi, Facebook.
He's got a completely different set of witnesses, the majority of which don't even really know the defendant, half of which were law enforcement.
Mr.
In rejoinder, Judge, I have 1, 2, 3, 4, at least 4 or 5 witnesses have written to you on behalf of Ms. Candace Ruiz, Mr. McDonald's ex-wife. She's not, as my colleague just pointed out, she's not even involved in this case. That she bears him ill will is not meaningfully in doubt. In fact, her lawyers are in the courtroom. She's been in every one of these criminal proceedings. Now, this has been...
Well, again, that has to do with sentencing.
Well, yes, I'm going to
tell me if you have any rebuttal regarding continuing the sentencing today.
Yes, I now have 4. I've got to figure out why I've got 4 witnesses that have come in on a case that my colleague said the witness wasn't a part of, and is now having and asking the court to impose maximum sentences on Mr. McDonald. The bile literally drips off these letters from his wife and his ex-wife and her friends. I have not had time to review these letters or investigate them. I'd also like to figure out by what mechanism they're even relevant, and I'm going to need to put into writing a motion to exclude.
I have not had time to read these letters, Judge, but the vial dripping off is terrible.
Exclude them, or to ask the court to exclude them as they are not relevant to the issues.
All day, all night,
I tend
every
to
day.
agree with you, but
yes.
Again, what does that have to do with going forward with sentencing today?
Well, it's a court of club.
If you want to ask when we get to that they be excluded, I think you're absolutely right.
All right, thank you. I would like to continue this I can investigate what exactly happened with this camera crew. This is a very unusual case, the court's well aware. I believe he should be given the own cognizance, and I asked to set the sentencing up. They're recommending probation. He's got 533 days in, Judge.
That is not correct. And I don't know if Your Honor saw the supplemental.
All right, no.
No.
All right, as far as continuing the sentencing, this has been, I believe, as I said before, almost 3 months since the trial, and certainly had you wanted to file some sort of a motion regarding that, you certainly could have. What happened in this new trial doesn't require or suggest that we should delay sentencing in this trial. I don't have any, not just authority, but even knowledge of what is going on there. And again, you have options after that, but to delay sentencing further, I just don't see any grounds. And as far as the camera crew, I have said and repeated, and I understand you've clearly made your record several times regarding your disapproval of the camera crew. Our Supreme Court has said that the presumption is we have an open court, and that certainly the media, and that's a broad term. We went over this and I spent probably 10 minutes during the trial and since, etc. But for the record, I'll do it again. The media, that's a broad term, and our Supreme Court has said that the media can be present except for unusual circumstances. There haven't been any grounds to exclude the media that I've been presented with, and so based on all of that, I'm allowing the media, and we're going to go forward with sentencing today.
Life in prison without the possibility of parole.
State.
Thank you, Your Honor. I want to note at the outset, in the
That's
original
good,
PSI,
Monica.
the department
I hope it
incorrectly
works.
stated his credit for time served was over 500 days. They seem to, you probably noticed this yourself, but I wanted to make it clear for the record. I notified them and they did a supplemental PSI, the only change being they corrected the credit. He has 117 days credit for time served.
I've never seen this supplemental PSI.
Would you like an extra copy?
Yes.
And for the record, when I looked at it, the only difference in the supplemental PSI was the correction to the credit for time served. So correcting it from over 500 days to 117 days.
No, he should have more than 117 days in, because I had him remanded into custody. I actually put it on counter and had him remanded in custody concurrent with the misdemeanor. That's another 180 days that are unaccounted for. So,
And Your Honor, I believe the number of days here are correct.
All right, we can get to that. I knew when I saw the first one that it wasn't 500 days, which would be close to 2 years. All right, go ahead.
And Your Honor, I request today that you give the defendant a prison sentence. I realize that the department is recommending probation, but that is clearly based upon the formula that the department uses, which heavily weights a defendant's lack of felony history. And despite his lack of felony history, the defendant, over the past year and a half, has demonstrated that he will not be successful on probation if he's given it. He is entirely unsupervisable. There's no question that if given probation, he will not follow the rules, no matter how clear, and he'll violate, and ultimately he'll end up in prison anyway, most likely after.
Bossy's always here.
And I won't belabor the facts of the instant case because you presided over the trial, but I want to discuss some things that could not be brought up at trial. I was informed by Timothy Spees, one of our witnesses at trial, who has been a marshal at family court for a long time and is very familiar with the defendant. He once found the defendant to be carrying a knife on his person when he was entered.
I'm supposed to be allowed to see what evidence is going to be presented in an argument. Now, I've already moved to exclude these letters. Now I've got a hearsay account.
And Your Honor, I object in interrupting my argument. This is sentencing.
Sentencing on a trial is
Yes,
done.
but hearsay,
This is completely inappropriate.
hearsay admission, are asking me to consider information that's totally outside the record. I certainly certainly never had it. I don't think you saying what he's told you outside of what he testified is appropriate, so I'm going to exclude that. Go ahead.
And, Your Honor, the defendant has a lengthy history of not respecting court orders. 3 times he's been convicted in Las Vegas Municipal Court of violating restraining orders against his ex-wife. He pleaded no contest to the 2017 count, which included a requirement of no contact with his ex-wife other than through talking parents. And he's repeatedly had issues with contacting his ex-wife in various creative ways. And importantly, when his suspended sentence for one of those counts was imposed in municipal court, he fought with the marshals very violently. I've seen the video of him doing so, and that resulted in his conviction for resisting arrest. And we all know he did the same thing in this very courtroom on July 22nd when he was remanded in this case. Okay, I was there. 2 marshals weren't enough. They had to call for backup in order to put him in handcuffs. He clearly has huge problems with authority. He just doesn't respect the rules that he's given. He doesn't respect the judicial system, and that's why he would not be supervisable on probation. And again, why was he being remanded in the first place? For violating the court order and making contact with his ex-wife, Candace. And I want to note that the PSI mentions his BDB arrest and puts no disposition. The paperwork that I have shows that in addition to his misdemeanor convictions for resisting arrest and violating restraining orders, he was also convicted of misdemeanor battery domestic violence in January 2017 in case C1166005B. So despite defense counsel repeatedly saying he has no history, he actually has quite an extensive misdemeanor history at this point. Additionally, there were certain findings that Judge Markey made in family court that I think are relevant to whether or not he would be supervisable. I know they're not things that were introduced at trial, but they're things that I've witnessed.
Objection. Judge Markey wanted nothing to do with this.
Well, if they're part of the court record, then I think they are admissible.
Okay, so that's the reason I bring them up. Judge Markey, throughout the family court hearings, stated that the defendant had put a tracking device on his ex-wife Candace's car, as well as disabled the engine of her vehicle. In November of 2016, the defendant was found to have violated the restraining order by entering his daughter's daycare facility and initially picking up the wrong child.
Excuse me. This is nothing but
All right,
hysteria.
counsel, you can object and then make your objection. Mr. Mueller, do you have an objection?
Yes, beyond the scope and it's outside the record.
It's apparently in the court record from family court, which I think is admissible. Is that what you're referring to? Go
Yes,
ahead.
I'm referring to the record from family court that I
Go
reviewed
ahead.
in the course of this case. And that incident was the basis for I believe, his second conviction for violating a restraining order. The police were called when he wouldn't leave the daycare. Additionally, I brought this up when he was remanded before Judge Hardcastle did find it relevant. The defendant showed up at a CLE for the district attorney's office, and he became aggressive with
Hi,
Mel
Anthony.
Christensen and stated that he wanted to attend all of our CLEs and then ran off with our CLE schedule. Nell Christensen was very bothered by this particular interaction.
I'm going to be very, very, very upset with her if she does not object at least 7 times during his argument.
And it was a concern to our investigators who then had to increase security for our CLEs. Additionally, and this also comes from the family court, when Judge Markey was overseeing his family court case, the defendant contacted Judge Markey's husband, who's an attorney in town, and talked to him about hiring him. They have the same last name. It was pretty obvious that he knew he was contacting the judge's husband. It's unclear what he was trying to do, if he was trying to get information about Judge Markey or if he wanted to create a situation which she would have to recuse herself. But according to the record Judge Markey made, I watched this on video, the defendant
No.
called her,
No professional,
called Judge
no.
Marquis' husband and told him what department his family court case was in. Her husband said, well, I can't appear in that department, can't help you. The defendant kept trying to keep him on the phone and asking him to take his case. Those were the findings Judge Marquis made regarding that. Additionally, additional security precautions were taken regarding him contacting Judge Marquis and her husband. And additionally, when this initially happened, I didn't think that much of it, but in combination with his other behavior, it concerns me more now. He, back in April, when the defendant was initially released on house arrest in this case, as J.P. Rahman, my co-counsel in the defendant's other case, and I were leaving the Clark place in the crosswalk, the defendant suddenly appeared walking the crosswalk toward us and approached us. And he stated hello, hey, and said something along the lines of, it would be nice if you stopped maliciously prosecuting me, and then just kind of laughed and walked on. I didn't really think much about it, but in combination with his tendency to contact people who are connected with his case, it's kind of concerning for me. And I find it kind of offensive that he's acting as if this entire case were a joke by laughing at it. Additionally, I reviewed his records from CCEC. He's had some disciplinary issues there as well. He's been placed in disciplinary housing, commonly referred to as the hole, for not following orders. He initially refused to submit to a strip search, which was required after he was leaving the program, and he argued with the corrections officer, stating that it was a violation of his constitutional rights. As a result, he was placed on lockdown. He didn't comply with the lockdown by being in his cell where he was supposed to be. So again, this is indicating he's not going to comply with authority. He would not be successful on probation. And returning to the case at hand, what's particularly odious in this case is the defendant's perjury. As we know, the defendant testified before family court that he was unemployed and had no income other than a small amount through odd jobs. And in reality, he had a full-time salaried position. And we all know what his motive was for doing that. He didn't want to pay child support. He wasn't, excuse me.
I object to that statement. It's not in the
It's
record.
argument.
All right.
It is in the record. This was the video that was introduced at trial.
Yes, I saw it. Continue. Overruled.
He wasn't confused or nervous. We all saw the video of him testifying under oath. He was quite calm. He clearly stated, very sadly, that he had been unemployed for forever. He knew that what he was saying wasn't true. Contrary to defense arguments, he wasn't confused, and he didn't have an attorney because his attorney had killed himself. He had an attorney 2 years prior to this, whose death was ruled a suicide in 2016. At the hearing in which he perjured himself was in 2018, and his attorney actually showed up at the beginning of the hearing and withdrew, stating that he felt he could no longer continue representing the defendant due to them having different ideas about how to proceed with the case. I mean, further, the defendant has been stating that he's been working for defense counsel as a paralegal. Okay, he's not someone who's entirely unfamiliar with the concept of perjury. He knew that that was what he was doing. And he repeatedly states that his motives for this are that he just wants to see his kids, but his actions are not the actions of someone who just wants to see his kids. A great way to make sure that you get to see your kids is to not commit perjury, not lie about the money that you have that you can use to help them, to not submit forged documents to the court, to abide by court orders. If he really wanted to see his kids, if that were what was driving his behavior, then he would have behaved very differently. And repeatedly it's been argued that this was a political prosecution when it simply was not. And defense counsel has repeatedly attempted to downplay the defendant's actions by saying, well, it doesn't matter because it all happened in family court. Family court is not some alternate universe in which actions have no moral or legal consequence. Nothing could be further from the truth. And nothing that happened here was the fault of the defendant's ex-wife, Candace. She had nothing to do with this case coming to the attention of the police or the DA's office. There's no doubt that tempers and emotions run high in family court. Maybe most people aren't really at their best selves when they're appearing there. But the defendant wasn't prosecuted for getting confused or losing his temper or getting upset. He was prosecuted for being a liar. He lied to the court. He did so repeatedly. He did so blatantly. And he publicized his actions himself by putting a all these hearings on the internet. His actions are his fault and no one else's, and they're highly offensive. And I ask that you give the defendant credit and that you impose a sentence of 24 to 60 days. And I want to again note for the record that he only has 117 days credit for time served. And with that, I'll submit.
Thank you. Mr. McDonald, before your attorney speaks on your behalf, is there anything you'd like to say?
There's a lot of
Okay, Mr. McDonald.
Yeah.
And Your Honor, I misspoke. It's the 24 to 60 days. I meant 24 to 60 months.
Judge, there's a lot I would like to say in the
True.
attention that was never brought up. But I'm under advising of counsel, I just like to say that I apologize for this case even coming before this court. It should have stayed in the court. I'm sorry. Just wanted that.
Thank you.
Wow.
Mr.
Your Honor.
His counsel shut him up. Nope, Debbie, they're sentencing right now.
With deference to my colleague who's never appeared.
Counsel,
Thank you, Your Honor. Pursuant to the conversation at the bench, we'd accept the court's proposal.
all right, then I will continue this for Mr. Mueller to apply to mental health court. It is I'm told, a 1 to 3 year program, but it's my understanding it is successful. They will monitor if in fact he's accepted. And it's not simple. I don't want to, I think maybe Mr. Mueller, you're as familiar as I am with it, but in any event, it's 1 to 3 years of constant supervision along with making sure that appropriate meds or whatever. So, all right, I'll give you 3 weeks to, I think that's plenty of time to apply for...
We'll get it done sooner, Judge. Maybe 2 weeks. Mr. McDonald, I'd like to give Mr. McDonald.
All right, 2 weeks, defendants remain in custody, and we'll continue this to see
Yes,
what,
right there, a second.
see what they say. All right, thank you. 2 weeks of what?
That's January, or November 13th, 9 a.m.
So, you're green again.
All right, thank you.
And if Your Honor, is the defendant's OR motion and it's off calendar for now?
It's off calendar, yes.
Thank you, Your Honor.
I'll go this way.
Just a second, guys. Just a second.
All right, present.
All rise.
Good afternoon. Please be seated.
Good afternoon.
Okay, we're here in case C-18-333-684-1, status check and defendant's request for his release on his own recognizance.
Good morning, Your Honor. Good afternoon.
I know.
Mr. McDonald, he's present in custody.
Good afternoon.
Mr. McDonald had been out of custody. There was no allegations that he committed any additional crimes or that he was a threat to the community. He was remanded into the custody in this particular case on a bond surrender. Now that we've been to trial, or so at least picked a jury, and through no fault of Mr. McDonald's, a mistrial was had, I'm going to ask the court to release him on his own recognizance. As an officer of the court, this morning, Judge Israel sua sponte indicated that he wanted Mr. McDonald to interview for mental health court, so we've not had a formal sentencing had on the other case. Though we did begin arguments and got a little contested, but Judge Israel sent him over for evaluation for mental health court.
All right. I did review your written motion. I'm assuming this is just a typographical error. It says that probation is, or parole and probation is recommending probation. Is that just a?
That was the recommendation on the companion case we had.
Oh, on the companion case.
Relatively,
Okay.
I had very little time to get that done, and I dictated a motion to my staff over the phone, so I apologize.
Oh, that's okay. I just wanted to clarify for the record.
The recommendation on the companion case was for probation.
All right. And to clarify, what was he convicted of in front of Judge Israel?
We went to trial on that case, Judge, and as a result, we ended up with a lot of convictions. We did get a not guilty on one. We got convicted basically of filing a false affidavit, a financial record of, and I don't want to misspeak. My memory's not as good as perfect. Burglary for entering the courthouse to file the document, filing a family court. Okay, thanks, Mike. And filing other false pleadings in family court. In this case, and I'll say this without a touch of irony or emotion here, was that case is the most unusual case I've ever handled. It appears to be from his efforts as a pro per litigant in the family court.
Okay. All right. Thank you. All right. I'll have the state respond to the motion for his release.
Your Honor, I do not believe that good grounds have been demonstrated by the defense, nor when you look at the totality of the circumstances, does Mr. McDonald appear to be in any way, shape, or form an appropriate candidate for any kind of own recognizance or reduced bail. The history and circumstances of the cases which put him in custody, because they're unfortunately intertwined, given that Mr. Mueller's representing a bond surrender occurred, which is why he's in custody on this case, is that over the past 2 years he's been in and out of jail. He's been in and out of jail because he violates court orders on a regular basis, that he's been convicted of violating protection orders, multiple counts of that, domestic violence, specifically restraining orders, harassment, things like that nature on his ex-wife. His ex-wife is the victim here in our case.
Okay.
In addition, when he did get in trouble in those cases and sentences were imposed, they were imposed for a reason, because he was continuing to offend. And then in one particular instance in the municipal court, when he was having a sentence imposed, he started fighting with the marshals, for which he got a resisting officer charge, which he was convicted of and did another 90 days on. Then, several months ago, when he was arguing his bail status, and we actually had to put a motion on remand based upon some very unusual behavior by the defendant, specifically him trying to contact people associated with the case, him running into myself and Ms. Mishler in the street and trying to confront us about maliciously prosecuting him trying to attend some of our office's CLE functions and then stealing the calendar and saying he would be back, as well as, again, harassing the victim in this case by sending Amazon packages to her house, supposedly under the guise of presents for her children, even though it was on her birthday. We did a motion to remand. When Judge Kathy Hardcastle, senior judge, did remand him, and she was also familiar with his family court history, which includes him coming to the court, representing false statements to the court, him ultimately now being convicted for doing so.
I also cannot wait until tomorrow. Tomorrow, guys, right after Judge Fleischer's docket, around 1:30 Eastern Standard Time, p.m. Eastern Standard Time, I'm going to be doing a special daytime live, and it's really good. It's going to be so much fun.
Ms. Mishler's other case against him, and then other unusual things like wearing a bulletproof jacket to the court, which put everybody on alarm because nobody knows what somebody's going to do who has that. It's a secure space. Unless you're planning on doing something where you're going to get gunfire thrown at you, you shouldn't have anything to worry about in the courts. But that's what this man has done. And then when he was remanded after Judge Hardcastle did this, and both of these incidences are online on YouTube, having been videoed, he fought with marshals again. For reasons
I
that are
never thought of
unknown
that.
to me, when Mr. Mueller says, oh, this is the most unusual thing ever, I have no idea whatsoever why
I have
the
no idea
Judicial District
whatsoever.
Court did not pursue resisting charges on a man who's on video resisting marshals, yet again, who's already been convicted of it. It seems ludicrous to me, but he did it. Where was that? Judge Israel's department, which is, 15 C's and C's.
Okay.
Now, regarding this morning, Ms. Mishler argued for prison. She asked for 24 to 60 months in front of Judge Israel. She made a similar argument as to what I'm telling the court today, much more lengthy, much more detailed. And ultimately, Mr. Mueller disagreed with that. He believed that he should get probation, and Judge Israel had both parties approach the bench. I wasn't there, but from what happened from the aftermath of it, Judge Israel was contemplating potentially having him assessed for mental health court. What was verbally heard by everybody in the courtroom is Mr. McDonald does not believe he wants to participate in such a program. My understanding of mental health court is you have to want to be able to do that to be accepted.
That's correct.
I think that it would be extremely irresponsible for this court or any court to release a person where the judge is teetering on this man has mental health issues, mental health court is where I'm leaning, and just release him to the street with no any kind of support system or circumstances which would protect the community or himself from his actions. His actions are well documented, they've been well publicized. He is a dangerous person. And there's nothing in place, and there's no reason to justify releasing this man for any particular reason. Certainly what occurred yesterday in Your Honor's department is disappointing, but it is not in the hands of Mr. Mueller. It was not in the hands of the state. It was something that occurred happenstance by a misrepresentation on the part of media, not disclosing that this thing was being live streamed, and certain witnesses watching it, and then one of them being motivated by what he heard Mr. Mueller saying, late disclosings of evidence. Your Honor did rule that the media thing by itself was not the basis for the mistrial. It was the late disclosure of evidence.
Yes.
So based upon that, I don't think anything here has actually changed. Judge Israel was also very explicit. This man is to remain in custody during the period of the eval. He's not being released, even though there was some attempt to try to relax his custody status this morning. So for the aforementioned reasons, I would ask this court not to do anything to adjust his bail and leave it where it is.
Thank you. Mr. Mueller.
Was originally charged with county domestic violence. The case was so severe that the city attorney agreed to dismiss it as long as he stayed out of trouble. Mr. McDonald's ex-wife has appeared in every criminal proceeding, and then surprisingly, after the stay out of trouble order was in place, suddenly his ex-wife now claims that she violates it, and Mr. McDonald gets remanded into custody. Now, he's not the victim of a crime, he's a victim of a very sharp family court lawyer. Then when he's in family court, now he's in custody because of what the family court lawyer has done, they go in and they take in sheriff's sale his house. He's now barred from his children, he's lost his house, he was wrongfully convicted. And even then, he's not been violent to anybody, he's resisted on occasion where he's frustrated beyond redemption. This is literally the most unusual case I've ever seen. Is a bunch of people picking on one guy who doesn't have a lawyer down in family court. Now, he hasn't violated any orders in front of this court. He hasn't had any trouble with anybody other than when they remanded him into custody the one time, and he hasn't seen his kids. And I want you to understand, Kathy Hardcastle and I, Judge Hardcastle and I have a 30-year history. I've prosecuted against her and defended against her. She stood up and remanded Mr. McDonald into custody for sending his kids a Christmas present through Amazon.
In violation of a court order.
It was, respectfully, we didn't litigate it. It wasn't really violation of the court order. The paperwork was subsequently later amended. We didn't go back to that. All right. All right. Now the reality is this man has been rough treated by the legal system. Have you ever seen a wiretap charge? I'm
How
sorry.
are you?
I actually have.
Well, yes, in federal court you would. Sorry.
Yeah.
All right. I'll have to rephrase my statement. Have you ever seen a state court wiretap charge?
I've been on the bench since April, no, but I know that is a charge. And I assure you, when I was a prosecutor, we had to confirm when we were taking cases, there was a federal involvement as to not violate the state prohibition against two-party consent, as it's only one-party consent in the federal system.
Your Honor, respectfully, Mr. McDonald, this is the first I've even heard of as a state court wiretap case ever, and it is a direct outflow of his divorce proceedings. Yet again, this case will eventually end in not guilty. Well, it probably almost certainly is going to have to be tried. Having said that, I'm going to ask to reinstate him on own recognizance. Judge Israel's got the keys to the case anyway down the hallway, and we're going to go get him interviewed for a mental health court. This was not his fault.
Snoopy, that's
that,
horrible.
This case didn't get resolved today, this week.
All right.
I find you in contempt. I am going to incarcerate you.
As I noted, had reviewed the motion filed by the defendant and listened
So you're saying you can't say no to me? Whoa.
to the oral arguments of the defendant by his counsel as well as the state. Mr. McDonald, your attorney rightfully points out the factors I have to consider. Thank you, I'm a little short, so thank you for standing up. I have to consider when I'm considering release at any time, whether it's at the time of arrest or later for motions. They include things like length of residence in the community, the status and history of employment, and relationships with family members. So the first two of those three adhere to your benefit. You have a long time in this community, you had stable employment up until recently. Obviously, your relationship with your family has taken a turn that seems to not go well and seems to get you into more trouble. So that doesn't bear in your favor. I also have to consider your reputation and character and mental condition, your prior criminal record, including any failures to appear. I don't believe there are any failures to appear. Am I correct on that?
I believe that's correct.
All right, which it does adhere to your benefit. I also have to consider the nature of the offense in which you're charged with, the probability of conviction and the likely sentence as it relates to the risk of not appearing, and the nature and seriousness of the danger posed to the victim or any other person in the community should you be released, likelihood of any more criminal activity by you if you were to be released, and last but not least, any other factors concerning your ties to the community or bearing on the risk that you may not appear. So the last half of those factors are where you hit an uphill situation. Understanding that you didn't violate a court order in this case, you have repeatedly violated orders of the court, not only before Judge Israel, but as I understand in terms of family court. Now, you can disagree with that, but in the end, it's something that I have to consider. And when I hear that and I see that, my concern is that I could give you any order and you would defy that because you have a history of doing so. I'm also very concerned about the safety of the community and the alleged victim in this case. Your behavior of contacting the victim, approaching the prosecutors, providing false, you were convicted ultimately, and so 12 people convicted you of making false statements, or was it perjury or false statements, or both?
It was both, Your Honor.
All right, of both?
3 counts of burglary, 3 counts of forgery, 2 counts of offering, filing,
Right.
false documents for record, 2 counts of perjury, 10 felonies.
Okay, all right, thank you for that. And so those are multiple crimes of dishonesty, that weighs against you. And you have a history of engaging with the marshals when they try and take you into custody. So that, weighing all of those factors, I do believe that remanding you to custody.
Judge, can I
Hold on, let me finish my announcement here, okay, and then you can talk. I do remand you to custody is the right thing to do. We could talk about bail, but I think remanding you to custody and staying in custody is the right decision, so I'll hear from you now.
Judge, I already posted bail on this before. I was out for 90 days. I haven't gone anywhere near my ex for the past 3 years. I have a lot of ties to community. I have a lot of good family here. My breakdown between me and my ex-wife is, it's just that I've been staying away from them. I just want to see my kids, Judge. And it's been pretty soul-ripping not to be able to see them. So I stayed far away from her. I followed all orders to the T. Yet there was some contradictory orders at family court that were unfollowable, Judge, that was put up.
I disagree. I wasn't there, and I don't know. But I bet chat shut up. I bet they stopped saying all this. But again, I wasn't there.
I superseded the TPO that was put on the divorce decree that said I could have reasonable phone conversations, which now is in before you here, which I actually did 6 months for her recording me and wiretapping me. But Judge, I followed all the orders that I could to the best of my abilities. I've gone nowhere near her, and I will not go anywhere near her. I just want to be out and just be done with all this stuff and move on with my life. So I appreciate you consider that.
Well, I hear
Liar.
you, and I think that I think when you're saying that to me, you genuinely want to do that and want to comply with the court orders. Unfortunately, issues of the heart make people behave in a way that can be dangerous. And when I say dangerous, I don't mean that in a necessarily violent way, though it could lead to that. I say dangerous in a way that it could also mean you get yourself into more trouble. One of the things that I don't ever like to do, whether I'm putting somebody on probation or remanding them to custody or deciding to release them, is set them up for failure. And I think where we are right now, I think a mental health evaluation is appropriate. I think, I don't know if you're willing to participate in that program. It does require a willingness to participate, and if you don't, you would violate that condition. And so I think that is the right decision as we sit here today.
I have a psychologist, Judge, that I've been seeing in order to be able to take those steps to see my kids.
I think that's good news.
I also was off of an ankle monitor and been on an ankle monitor, gone nowhere near her whatsoever. I did send presents to my children, Judge. It was Father's Day. My son's 8th birthday is 6/16, and then I get thrown in jail. I was out on a $100,000 bail in another case, and then $15,000 here. I'm completely out of money, Judge. I've gone nowhere near her. I'm not going to go anywhere near her. I just want to be done with this case and have some resolution and just be able to
Liar.
Back to work and
Liar.
and eventually be able to see my children.
All right, well, again, like I said, I think when you're saying those words, you genuinely mean it. You are in a different position than you were when this bond was initially entered, because you had not been convicted in the case in front of Judge Israel. You have since then been convicted, so that changes your criminal history. The initial bond that was set in this case was $15,000. That has been surrendered. Let me turn to the state. Are you requesting a no bail hold?
Yes, Your Honor, or maybe an alternative of bail of about $100,000. When that bail was originally set, in this case way back, we're going back maybe 2 years at this point, we had none of these things that we were arguing today at our disposal. This was just a guy who committed these 5 felony counts, and we had no idea what else he was capable of or what he was going to do. We're in a far different position today than we are back then, so I would ask for a no bail, or in the alternative, $100,000. And certainly there should be requirements with that bail, because my understanding is either his mom or his family member's house is exactly 1 mile or less from our victim's place of work. And I believe a family member of his actually attends the place. It's a high school. And one of his brothers is a student at that school. So it's a very difficult and trying situation for our victim.
The state constitution does not allow no bail holds, except for murders. And my colleague seems to understand something. There's not a crime of violence here. The one crime of violence that he was accused of was domestic violence. The city had initially agreed to dismiss. It was so inconsequential.
Then he had two run-ins with the marshals.
Yes, he did tussle with the marshals. He didn't punch them, didn't kick them. He just kind of passively resisted them the first time they went to the ground. I'm not walking away from that, okay? It wasn't very wise, but at least I understand his frustration. Now, he's been rough handled down in family court. Whether any of those convictions actually stand or not, we'll see what the appellate courts want to do. But on aggregate, my colleague keeps standing up and saying, dangerous. He's not dangerous. He's in his mid-30s, early 40s, with zero criminal record until he gets sideways down in family court. Now, in a very real system, in a very real sense, and I say it like a touch of irony, this system has turned him into a criminal. Now, they've stolen his house, the wife has stolen his house, she's hysterical mongering. You should see these letters. If he had been the shooter on the grassy knoll, they would have written it in the letter. Now, these are nonviolent, this is a nonviolent offense. The only person's word we're gonna have to take from it is people who demonstrated that they have hostility towards him here on this case. Wiretapping. The state won't even be able to show that this wiretap was done in the state, if it was even a wiretap at all. Respectfully, Judge, he's entitled to a reasonable bail. I'm going to ask for, if nothing else, to reinstitute $15,000 bail. $100,000 is disproportionate, violates the state constitution, unreasonable bail. And the bail is only, it's not punishment, it is to determine and make sure he's returned to court. He has never missed a court date. In fact, candidly, it might have been better on a couple occasions if he had missed a couple court dates. But the reality is he's never missed any court dates either. And he actually does have a history of being involved in community projects, and as the court's aware by now, he's tied to a couple of very prominent families here in town. He's not going anywhere.
May I make one clarification, Judge?
Yes.
With regard to the last comment said by Mr. Mueller, his ties to very prominent families would be the Bonaventuras. With regard to his earlier remarks about nobody having been charged with wiretaps, I have an open trial on Mr. Bonaventura for said charge. I have multiple cases where people are being charged with doing the very conduct Mr. McDonald is. And it isn't lost on anybody that is his family member who's doing the same criminal conduct. So these are the people who were around him when he was committing these crimes. I don't think having them now should make anybody feel any more comfortable.
All right. What is the case number in front of Judge Israel? Do you have that handy?
Did bring a file to
It's
this.
C335284.
2335. Can't read my own handwriting, all right.
The next court date on that is November 13th. That is the status check to determine some outcome on the mental health court evaluations.
All right, I'm looking at the PSI for that case. I do think it's relevant to my determination here. I'll note that the PSI states the defendant was diagnosed with an adjustment disorder due to his divorce. And I'll also note that he has multiple misdemeanor convictions, a 2016 violating restraining order, the same for 2017, the same for 2018, and then the 2018 resisting public officer.
Yeah, but his attorney is listening every time he whispers this time. I think his attorney needs all the help he can get.
He's also been charged with a number of offenses which he has not been convicted for. They were dismissed: domestic battery, burglary, forgery, and the offer of false instrument of public offering. It seems like that might have been incorporated into the ultimate case before Judge Israel. There's also a modified protection order in place. Has that been extended? It looks like it was set to expire October 3rd. Do we know?
The protective order in family court,
Mhm.
I believe it was extended, but I'm not 100% certain.
Okay, all right.
It was extended, that was the document I was telling you about, that's
Okay.
when they added, that's when they added no contact or no gifts for the kids.
Understood, thank you.
That's was, we didn't litigate that, but
Understood.
McDonald was on received an injustice on that.
All right. Okay, so I am going to issue a bail. It will be $15,000 per count. So that's going to be a total of $75,000 bail in this case. If the defendant is able to make bail, he will also be subject to house arrest and high-level electronic monitoring. I will also issue a stay-away order from the alleged victim and their minor children in common. He is to have no contact with the victim or their minor children, either direct or indirect. To the extent that family court modifies that order, then this order will mirror the family court order, so they are consistent. Does the state ask for any additional conditions?
No, Your Honor.
No, I think that's sufficient.
We're going to go for a speedy trial right then. There's zero chance he's going to make 75,000, Judge, so we can get the trial set as soon as possible.
Your Honor, with regard to your earlier question about additional conditions,
Yes.
if we could have a specific order to stay away from Bonanza High School, that is the victim's place of employment, which is very close to defendant's mother's house.
Yes, there'll be a stay away order from Bonanza High School. The defendant cannot be within, is 1,000 feet sufficient?
Yes, Your Honor.
All right, 1,000 feet of Bonanza High
I know
School.
that when the court pronounces specific places, then the house arrest unit will input those in the device and it will trigger. With regard to defense's request for a speedy trial right, there's no state recognized right for re-invocation. However, if he wants a trial sooner than later, certainly within our calendars, we can try to accommodate that.
Yeah, we can set it as soon as possible. When's our next trial staff? Our next trial strike is in January.
That would be sufficient.
Mr. Mueller, how's your calendar looking in January?
I'll make this work, Judge.
All right, we can set it early, our earliest possible setting.
January, December 18th, calendar call, January 6th.
Mike,
December 18th, calendar call, January 6th.
All right.
Calendar call is at 8:30 in the morning, trial is at 9:30 in the morning. All right, thank you all for being here this afternoon, I
Thank you.
appreciate it.
We appreciate it, and our experience in the limited amount of trial was pleasant, most of the things.
Oh, thank you. Well, it was a pleasure to have everyone before the court. Thank you.
There's no
Judge,
mechanism.
I'd like to bring back the trial, please, Judge, with the same jury. This is ridiculous. I'd like to vote my vote.
Well, the mistrial has been declared and we can't undo that now. So we will, we do have a trial day set for you, and we'll get you tried as soon as possible. Thanks, everybody.
Thank you.
Your Honor.
Officer, would you keep?
Three, three, 284. Council's nature appearance.
Good morning, Your Honor. Karen Mishler on behalf of
And good morning, Your Honor. Jay Maynard, bar number 14738 with Mueller and Associates.
Council approach.
Hi, Nancy. I think he likes the camera.
All right, I understand Mr. Mueller is still working on the
This isn't a new attorney.
paperwork.
Exactly. This is a different attorney in Mueller's law firm that helps. He helped one time before when Mueller couldn't make it to a hearing. So I guess Mueller could not make it to this hearing.
For the evaluation, so we'll put it on the 9th.
December 9th.
Yes,
Are we continuing to look matters for Courtroom and calendar?
yes.
Thank you. December 9th, 9 a.m.
Thank you. That concludes calendar, Judge.
Thank you.
Remain seated and come to order. Department 28 is again in session. Page 6, McDonald.
Page 6, McDonald, Mr. Mueller.
Good morning, I'm going to go back to Mr. McDonald.
Good morning, Your Honor. Karen Mishler on behalf of the state.
Has he been accepted into the mental health court?
I haven't seen anything, but did you fill out the application?
My understanding was they filled out and sent over.
Typically, defense counsel is notified of his acceptance or rejection.
Well, usually we get it, and I haven't, so.
All right, Judge, I'll make some phone calls. Everything gets more bureaucratic. I'll see you.
Wednesday.
Was that?
Wednesday?
Sure. I'll follow up.
This Wednesday, the 11th?
Yeah.
Okay, December
Which,
11th, 9 a.m.
off the top of my head, it keeps changing. Who's in charge of mental health court? Do you know? I'll call Chambers directly if I know what's the application.
Mental health court is Department 11, but it's under Jaeger. When I send off emails, it goes to Catalina Moros.
Well, which department do I call to find out what the application is?
Or you can call Department 11.
Okay. Department 11 it is.
But Your Honor, could we still deal with the defense's motion that was filed on October 30th to stay adjudication and schedule evidentiary hearing? I think we could dispose of that.
We can do that now or Wednesday.
Let's do this. Let's do that with the judge. We'll put it all together. We'll get a coherent result.
I mean, is the other case?
The other cases did not settle.
I don't think it's yours. No, I wasn't talking.
Oh.
I'm going to stop my whole stream just to say, Micah, you better be following the rules here.
That's the word. That's the word.
Wednesday.
That's page 8.
Page 8? Okay.
Page 8, Ellis.
I almost laughed during that. I had to stop myself. No, doctor, there are no rules, I don't think. Oh, no politics and no bashing any other channels. No, no, no.
Where's Mr. Mueller?
We received an email.
Your Honor, Karen Mishler on behalf of the state. Just a few minutes ago, I got a copy of an email that was emailed to Your Honor's clerk. I think it was the same email. It indicates that Mr. Mueller submitted the mental health court application yesterday, but it was incomplete due to not containing medical records. And thus, even if medical records were received today, it seems unlikely the defendant's case would not be staffed until December 31st. At this point, Your Honor initially ordered.
I'm sorry, another Smith. But come and listen and laugh. Thank you so much. I appreciate it. Thank you.
Had been already submitted. It looks like that may not have actually been the case. At this point, it seems unlikely that the defendant is going to end up in mental court.
All right, where is Mr. Mueller? Call him. He needs to be here. This coincidentally is exactly what he was asking for in his motion, to stay the proceedings. I gave him now, what, over a month to apply. He hasn't done it. He's not even here. Get him here. Get him on the phone. Tell him he's going to be sanctioned if he's not present.
Yes, Judge. Page 1, Halliburton.
Okay, we approach it.
Yes.
I think it looks nice. Oh, he's probably still sending our Nevada judges all kinds of letters and messages and everything. Poor guy. I 100% support that decision. 100%. Snacks, not razors. Snacks, not razors. This lawyer is hired, not assigned.
January 1st.
That's January, we are 15th, 9 a.m.
All right, thank you.
All right, we have one more short one. All right, I'll play. I was going to skip it, but
333684-1, State of Nevada versus Michael Lee McDonald.
Good morning, Mark. We're going back to Mr. McDonald.
Good morning. Good morning.
Good morning, Your Honor. Karen Mishler and J.P. Rahman on behalf of the state.
All right.
Your Honor, before we proceed, the political pressure group has its camera here in the courtroom again. They caused a mistrial last time and successfully gave my opening statements and theories of the case to the witnesses. Can we make sure that they be instructed not to do that again?
Well, in this instance, it is a public proceeding and I will allow them to film. Certainly, I would caution the state to advise their witnesses not to watch. And if they do watch, that will be fodder for cross-examination at the time.
And we've already done so, Your Honor.
I appreciate that. So, Mr. Mueller, your request is denied, however, it is noted for the record.
I think, Your Honor, I'd like to have a continuing record objection to this particular group or this particular camera.
And you'll have a standing objection.
All right, thank you.
All right. So we
Mike, take a deep breath.
I got, that's what we got, I just want to see my kids, come on. I've done nothing.
Mike,
Just take it
calm
backwards.
down. Dude, take a deep breath.
Guys, come on. You're gonna really throw me in jail because I missed my kids? Come on. Assistance in 15 Charlie. 15 Charlie. Stop, come on, please, guys. Please, I don't want to.
You got it?
Yes. Let's just hold him. Come on.
Mike, stop fighting with the guys.
I'm gonna take her.
Mike, stop fighting with them. You have to come over there and help them with cuffs on you? Don't fight with them.
You understand? I'm gonna tase you.
Don't fight with them. With the handcuffs on? Mike, put the fucking handcuffs on. Or I'll put them on myself.
Great, come on.
I'm on your side, Mike, but you're out of line.
This is ridiculous. Like, there was no order saying I can't see my kids. It's the only thing.
Mike, just relax, deep breath. Mike.
We are here on defendant's motion to consolidate counts and motion to exclude. I have read the written pleadings as well as the oppositions to both motions. I'll start with the motion to consolidate counts. Mr. Mueller, anything you'd like to add to the written pleadings?
Thank you, Your Honor. I don't know if, I know you're busy. I don't know if you had a chance to read the preliminary hearing transcript.
I did.
The moment I learned about this case, I am confused and befuddled by it and remain so. at this moment. There is a recording. Who made the recording is not a scintilla of evidence in the record. Not a scintilla. The ex-wife believes it was her ex-husband because he's an asshole, basically, so many words. He's an asshole and he always records stuff. That's the entire evidence of who actually made the recording. Now, the odd thing about this recording is, and everyone in this courtroom has picked up a phone, and the first thing you say on the phone is hello, or hi, or Judge Silva, how can I help you? There's putatively 5 recordings made. None of them record a greeting or a goodbye. So I asked, the obvious question is how come there's not a greeting beginning with these conversations? Or how come there's not a goodbye, which indicates a full communication? None of them have that. Then you sit down, and when it's tedious, and I don't expect the court to have done it, but when you sit down and listen to this whole thing, it is very clear that it is one conversation. The background noises match up, the conversations fade in and fade out, they match up. It all is. This is actually one conversation, not 5. It was one recording, whoever made it. Number 2, several other problems here. I tried to get a sound expert to look at this audio tape. Guess what? These aren't original recordings. They are a summation given to the state by Mr. Mark DeCiro, someone who's also tied in with this pressure group here in politically. So now I don't even have the original recordings to determine how they were edited. So, best evidence rule. Where is the original recordings? Number 3, we have not a scintilla of evidence of where the recording was made. If you make this recording in California, you're lawful. If you make the recording saying, hey, I know we're not getting along, I'm recording this conversation on instructions with my lawyer, which is a very standard thing to do in a divorce case, and now you edit that out, you've made it an illegal recording. Now, where is the best evidence rule? Now, I actually, this case is deeply and fatally flawed. I'm going to object to the recording being admitted at all under the best evidence rule. I've not had a chance to listen to the evidence, look or examine it, have an expert witness look at it. It's clearly audited or it's been edited by somebody. It's not there. Number 2, the record is completely devoid of why one conversation is broken up into 5. And number 3, the transcript's completely devoid, the preliminary transcript, that he actually made the recording. It was supposition by his very angry ex-wife. And that's it. So respectfully, Judge, we move to consolidate the counts. Because, and if you want to take just a few minutes, you can listen to them. They fade in, fade out. The background noise is perfect. The conversation is subject. They all flow from one conversation. And I'm going to move that they be consolidated. I'm going to move to exclude the transcripts that I've been given, the tape that I've been given. It is impervious to review or analytics by an audio expert. Unfortunately, also Mr. DeCiro, the person who is putatively the source of these recordings, is a former disc jockey. Well, this is not only auditing tapes. I would have a hard time doing it. I guess with a book I could figure out in a few hours. This is what he did every day. So we have potential for mischief, no chain of custody, no authentication, an unusual background, and circumstances that all but imply something nefarious has been done here. And when you listen to all 5 of these conversations, you won't hear the word, oh, hi, or oh, it's you again, or hey, goodbye, or go to hell. It's a divorce conversation. They're not happy with each other. You know, they would be, all right, you go to hell, I'll see you in court. Click. Something that logically wraps up a conversation. None of that's in here. So respectfully, Judge, I honestly believe that you should consolidate the counts into 1. Number 2, you should exclude the audio tape that I've been given, citing the best evidence rule.
Okay. All right, for the record, Mr. Miller, thank you. You actually addressed both motions. So let the state know what I want to hear about. Mr. Mueller, based on my recollection of the evidence that was presented and some of the issues that came up during the last trial, the chain of custody, or at least the evidence of the chain of custody, would be that Mr. McDonald is the one who provided the recordings to Mr. DeCiro. So if there's a question regarding who has the best evidence, arguably it would be your client, and I'm confident you're not going to provide copies of recordings of the calls. Am I correct in that assumption?
I've got the entire body of evidence in this case is what the state has given.
All right. So I'm going to deny the motion to exclude based on the best evidence rule, but I do want the state to respond to the arguments regarding the fact that it appears to be one continuous conversation that's divided up into multiple parts.
Certainly, Your Honor. And essentially, Your Honor, defense counsel is mistaking his opinion for fact. That's his characterization of the evidence. He claims that these are all part of one phone call. The state will be calling Candace Ruiz.
I only answer the phone if Fozzie calls.
The ex-wife, who's the other
You can call me all day, all night. I'll never answer. I'll be playing a video game on my phone, not answering.
party to the phone calls, and she will testify that these were in fact separate phone calls, specifically based upon the context of the phone calls and the subject of their conversations. And there are various things that indicate they are separate phone calls. At one point, they discuss the fact that their daughter needs to be allergy tested, and in one of the later recordings, she indicates that the daughter has already been allergy tested, and now they have a diagnosis and they know what she's allergic to. That's just one example. There are a number of things. They discuss the divorce decree needing to be signed, and then in another recording, she refers to the decree as already having been signed. There are a number of indications that these are in fact separate phone calls, and our witness will testify to that. And additionally, the defense counsel is free to argue to the jury that he thinks, and they think that, and they should think that it's one phone call. But there's no requirement that we accept his interpretation of the evidence when that's a determination that the jury has to make.
All right, thank you.
I would just very briefly.
Yes, briefly.
No, and conversations occur, and maybe someone picked up the phone conversation the first time and said, yeah, or somebody's got fumbling 5 times. 5 conversations don't begin with a hello, don't end with a goodbye, or go to hell, neither. Nothing that logically. Not one time, which is okay, it's fair to argue. It's a consistent body of evidence that is clearly not what it's purported to be. And that the state is actually even trying to maintain that those are separate conversations is in and of itself kind of really reaching.
All right, well, thank you for the argument. As I said, I'm going to deny the motion to exclude. I'm also going to deny the motion to consolidate counts. I agree with the Supreme Court in the, I think it's Origel v. Candido case. It says, it's the jury's function, not that of the court, to assess the weight of the evidence and determine the credibility of the witnesses. So certainly, Mr. Mueller, you're free to argue that and to present that argument to the jury, but I don't have enough evidence before me or enough before me to suggest I should consolidate the counts. We could be in a different position at the end of the presentation of the evidence, and so I'm denying that without prejudice. And I would ask the state to contemplate a special verdict form that perhaps would encompass finding that these are different calls on different dates to protect the record should we get to that point regarding that issue. So those are denied, and I'm assuming we're ready for trial.
Yep.
Okay.
Yes, Your Honor.
All right.
Could we just put a rejected offer on the record?
Yes, you may.
And the state offered for the defendant to plead guilty to 1 count of unlawful interception of wire communications, and he would be given probation with mental health court, and that case would run concurrent to his conviction in his other case, C-335-284.
And that's the case before Judge Israel?
Yes.
Okay, all right. And Mr. McDonald, is that correct? You rejected that offer?
I haven't seen the offer, but it doesn't, I'm innocent, Judge.
Okay, so you haven't seen the offer. Had you heard the offer?
No, I have not heard of it.
Okay, so here's what we're gonna do.
There was an original offer of probation and everything as a wobbler, but
I'm innocent,
I didn't
Judge.
review that either, Judge.
Okay, so could you restate the terms of the offer again on the record? And listen carefully, okay?
Sure. The offer was for the defendant to plead guilty to 1 count of unlawful interception of wire communications in this case, and he would be given probation with mental health court, and that would run concurrent to his sentence given in his other case in front of Judge Israel, which is C-335-284.
All right, thank you, Ms. Mishler. All right, because he advised that he had not heard that offer, I'm asking that you keep that offer open until this afternoon. We're not going to be able to start jury trial until this afternoon because I'm covering arraignment court this morning. Would that be okay with the state?
That's fine, Your Honor.
All right, so Mr. Mueller would ask that you go back and talk to him about that offer. I understand that you maintain you're innocent, but certainly you have the opportunity to review and talk to your attorney about that offer. All right, so we'll be back here at 1 o'clock to begin jury selection. Because I am covering arraignment court, we can't start until this afternoon, which is my normal style, as you all know. But we'll see you and you at 1 o'clock. All right, thank you.
We're waiting until 1 o'clock, apparently.
We'll go on the record, KC 333684. Just want to make sure there's anything we need to address before we bring the jury in. All right, thank you. So,
Well, I think that you had us leave the offer open.
I understand it's being rejected, but let's just double check. Good afternoon, Mr. McDonald, how are you?
Good afternoon, Judge.
All right, let the record reflect the presence of Mr. McDonald and his attorney. I understand you're going to reject the offer that was made this morning, is that correct?
It's for a felony charge, yeah, I don't.
Okay, all right. So everyone, be at ease. We're just waiting for the jury to line up, and then we will get started.
Okay, thank you.
Thank you.
Oh, nice. We actually going to set up here. Was it?
I need for the ocean after that. See the ocean.
Yeah. I have to agree with you.
Howdy. Great. Is that on the record? All right. Here we go. That's on the record in KC 18333684, State of Nevada versus Michael McDonald. There's one juror I'm going to bring in first before we bring in the rest of the panel, and it's juror number 413. Apparently the juror services advise that he is a convicted felon, or she is, I'm not sure. But I wanted to talk to that person before we bring in the rest of the panel. So Greg, you go ahead and get a chance, and we'll get started with them. Good morning, yeah, let's call KC 18333684, State of Nevada versus Michael B. McDonald. Good morning, Mr. McDonald. Hi, Dr. Record about the presence of the deputy district attorneys as well as Mr. Mueller and his client, who is dressed out for trial. Anything we need to address before we bring the jury in?
Yes, Your Honor, the state actually has three things that need to be addressed.
Okay.
I think the first one will be fairly brief. The second
All right, Casey, wish me luck. Here we go.
that we'll be calling today, Detective Colby Karchner. The state is requesting no face filming for him due to the nature of his work. I've already spoken with the camera operator from the media. She assured me that she will not be filming his face, and I believe the procedure is for jabs that we would need the camera disabled that films the witness's face during his testimony.
Okay, and what is the nature of his work?
Potential undercover work in the future.
He does potential undercover work? Okay.
Yes.
All right, well, that will possibly be granted. I understand you're going to comply with that, so please, let us do the order of the court. And then, can you turn off the camera for him? How do we do that?
Let me, when is he coming on?
After lunch.
After
Yeah, he will
lunch?
be the second witness, and
Okay,
our
perfect.
first witness will be
So we'll get
much
that
longer.
Okay, let me figure that
Resolved
out.
after. Okay.
Okay,
Okay, thank you.
And also for the record, the camera operator assured me that there's no live streaming going on at the trial. They're just recording.
Okay, I appreciate that. Thank you.
The second issue, it came to my attention this morning that Steve Sampson, the head of Veterans in Politics International, who was here in the courtroom yesterday,
Sorry,
I haven't seen him
Casey.
today, he made a Facebook post. He made a Facebook post today in which he made a statement regarding who was on the jury panel. Specifically, he stated, Judge Christina Silva had jury selection for the Michael McDonald matter. Surprising there was a family court litigant sitting as a potential jury. I think he meant potential juror, not potential jury. Unfortunately, he's not here today. It's just, basically there are two things. I mean, one, I think if he were here, I think he would need to be admonished by Your Honor not to be posting things about the jurors. Two, I'm hoping that he was referring to the person that was in the potential jury panel who stated that she knew the defendant and marked a 0. That may be who he's referring to, in which case it's fine.
Right.
But if he's referring to somebody who actually got seated as a juror, that's concerning to the state, because yesterday during voir dire, my co-counsel asked all of the people on the panel if they were familiar with Steve Sampson. They all indicated they didn't. So if we have someone who's being dishonest about that, but I don't know how to deal with that if Steve Sampson's not here. But
And until that's brought to our attention, or if it's even brought to the attention, the jurors would have to bring that up. We're not, of course, going to have to operate, but also certainly note that, and if there's another issue, then we'll address it when we need to.
Okay. And third and final issue, yesterday defense counsel stated an intention to call a witness by the name of Scott Bradley. The defense has never noticed any witnesses in this case, so the state requests that the defense be barred from calling this person Scott Bradley pursuant to NRS 174.234. All witnesses must be noticed in writing along with the address of that witness at least 5 judicial days prior to trial. There was no notice at all of this witness. And to make matters worse, defense counsel may point out that there was verbal notice of the witness at the initial calendar call on December 18th, but defense counsel's associate actually stated that it was someone named Scott Bailey who would be appearing. So there's been no written notice at all, and arguably they've indicated that it was someone with a different name. The state knows nothing about this witness, and I think it would be unfair for them to call this witness. Additionally, based on questions that were asked during voir dire and statements made by defense counsel at the last mistrial, it appears that defense counsel intends to argue that the defendant was outside of the jurisdiction at the time these phone calls were made, and the state's position is that's essentially an alibi defense. Black's Law Dictionary defines an alibi as a defense based on the physical impossibility of the defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant date and time. That's essentially what that defense is. And as we all know, pursuant to NRS 174.233, such a defense must be noticed at least 10 days prior to trial in writing, along with noting the witnesses, the nature of the alibi defense, and the witnesses who will be presented regarding that defense.
All right, so let's take the witness first. Ms. Mueller, is it still your intention to call that witness?
We've been investigating and trying to get hold of Mr. Bradley. We have not been able to do so.
So that issue seems probably will likely resolve itself. So I'm going to defer on that ruling until it is an issue. However, if you do intend to call him, you will have to let the court know ahead of time so we can address the lack of notice issue outside the presence of the jury. Turning to the alibi defense, Ms. Mueller, do you intend on calling a witness that is going to put your client in California at the date and time, or outside the state of Nevada?
I respectfully decline to play my defense for my colleagues before it's presented. Number two, my colleague in her industry seems to confuse two very basic concepts. Alibi defense was I wasn't there. Jurisdiction is absolutely a central element of every crime charge. It might be the most heinous murder in the world in New York, and my colleague can be upset if she wants about it, but the reality is there's no jurisdiction in Nevada for it. Now, if this phone call was made in California, there's no jurisdiction. You still have to plead and prove jurisdiction just like any other proceeding. So I believe now, this is a divorce. I don't know if the court's had the pleasure of actually going to family court. There's been absolutely no cooperation with any witnesses prior to trial. What the testimony brings today is going to be what it brings. So we will have to respond to testimonies as adduced.
All right, Ms. Fisher, how do you respond to the fact that he's arguing this is an alibi as much as a jurisdictional argument?
I understand that jurisdiction is related to this, but essentially if the defense is, well, he was in another physical location at the time of the offense, that is the essence of an alibi offense as well, even if it is relevant to jurisdiction. He's saying it was physically impossible for him to commit the crime because he was in another physical location at that relevant time, and that's in essence an alibi defense, and there's no reason that written notice could not be given of it.
That's not an alibi defense. That's fundamentally different concepts. My colleague is trying to protect her case prospectively and asking the court for an advisory opinion, and I object to both.
denying the request to preclude argument that the defendant was in California, certainly the defendant is going to have to put forward more than argument to support any claim that he was in California at the time. This is shoehorned to another concern the court has based on questions that were raised during voir dire yesterday. There were questions about an understanding of whether there's different laws that take place in different states and federal versus state law. Mr. Mueller, I understand you have a right to question the jury, but you don't have a right to confuse the jury regarding what is going to be the applicable law in this case. And to be clear, the applicable law and the laws that he is charged with violating our state of Nevada laws, and so there is going to be a question as to relevancy regarding other laws of other jurisdictions. And so I'm cautioning you now, as in the presence of the jury, to tread lightly as to not confuse the jury regarding what is appropriate and what they should be considering.
I understand, Judge. I've got supported case law, and when I get to the jury instructions, we'll see exactly where I'm going.
Well, I will want to see that case law before we get to the point of jury instructions. If we're going to be arguing that in front of the jury or asking questions about it, I think it is important that I review and make a decision on that issue well before we get to the issue of jury instructions.
Thank you, Judge.
All right, so anything else that needs to be addressed?
Not from the state, Your Honor.
Okay, all right. Thank you, and if anything else is brought to your attention, please let me know. Let's go ahead and bring the jury in.
Me too, Sherry.
Jury?
Hi, squeaky chair.
We will take this case under
Squeaky chair, they played the intense music for you.
submission.
That would require proof by very significant evidence.
All rise for the jury. Jury is all present, Your Honor.
Good morning, please be seated.
Kelly, I don't ask anymore. I just watch.
Yes, Your Honor.
Yes, Your Honor.
All right, welcome back, ladies and gentlemen. I see many of you have jackets or scarves, smart, hiding ahead. Today we cool, tomorrow we'll be hot. You can tell with the temperature control in here, so I'm glad you're prepared. We're going to start this morning. I'm going to read you some pre-trial instructions, and then we're going to proceed into opening statements. Just to give you a little bit of a preview on timeline, I anticipate we'll go for about an hour and a half, and then we'll take a lunch break, and then we'll come back and we'll resume with the rest of the trial this afternoon. So we're going to go ahead and get started with these pre-trial instructions. Ladies and gentlemen, you're admonished that no juror may declare to a fellow juror any fact relating to this case of his or her own knowledge. And if any juror discovers during the trial or after the jury has retired that he or she or any other juror has personal knowledge of any fact or controversy in this case, they should disclose that situation to me in the absence of other jurors. Let me decode that for you to non-lawyer talk. That's an instruction I'm required to give, but what that basically means is you are required to let me know if during the course of the trial or even during deliberations that you realize that you know something about this case that you didn't know previously. As an example, sometimes a an individual you know as William is announced as being William Smith comes in, and turns out that William has a nickname named Buzz. You only know William as Buzz, and so that person walks in the door, the person's a potential witness, you're like, oh, I know that person, that's Buzz. You were to write that information down on a note, don't share it with your fellow jurors, get it.
Without her consent, wherein they discuss court issues and or dietary needs of the children, signed by the district attorney, to which the defendant has pled not guilty.
Thank you, Ms. Montague. All right, we are ready to begin opening statements when you're ready, Ms. Fischler.
Thank you, Your Honor. Ladies and gentlemen, this case, the state of Nevada versus Michael McDonald, is about privacy, a criminal violation of privacy. The evidence will show that the defendant, Michael McDonald, recorded 5 telephone conversations that occurred between himself and his ex-wife Candace. And the evidence will show these phone calls occurred between August 1st of 2016 and November 30th of 2016. And you'll hear testimony from Candace. She's Candace Ruiz these days because she's remarried. At the time of these phone calls, she was Candace McDonald. And she will actually testify that she's certain these phone calls all occurred in October of 2016. But to cover our bases, we charged this particular time range just to be sure we were accurate. And you'll listen to these phone calls. And on these phone calls, the defendant and Candace, they discuss very personal things. Their past relationship, child custody issues, daycare costs, and health issues regarding their daughter. And I apologize to you if you're the kind of person who gets grossed out easily. You'll hear more about their daughter's bowel movements than you ever wanted to know. And if you don't know what a rectal prolapse is now, you'll learn what that is by the end of the trial, which you probably don't want to learn. But unfortunately, that's the nature of what they'll be talking about on these phone calls. They're very private, personal things, not things that Candace expected to become this public of nature. And to give you some background, the defendant and Candace, they met at a country western music bar in 2008, and they got married in 2010. And they had children right away. They have 2 children together, Mason and Malia. Mason was born in 2011, and their daughter Malia was born in 2014, and she's the one that you'll hear the most about. Candace files for divorce in 2015, and the divorce is finalized in October of 2016. That's when the decree of divorce is signed and the divorce becomes official. But of course, as you probably know, since they have children together, their family court case isn't over just because they've gotten divorced. They have child-related issues that they have to deal with, child custody, child support, things like that. So there are repeated family court hearings involving the defendant and Candace. And so now we're into late 2016, 2017. The defendant is not happy with how his family court case is going. He doesn't like the judge. He thinks the judge is biased against him. He's not happy with the child support. He's not happy with the child custody arrangement. He just feels he's being treated unfairly. And he gets a video of a number of the hearings that occur in family court in this case, and he posts them online, some on YouTube, other websites, and he starts talking online and posting comments, complaining about how he's being treated in his family court case and asking others for opinions and advice about his case. And this is how he comes to the attention of Mark DeCiro. And Mark, some of you recognize him because of his former career in radio from Mark and Mercedes in the Morning, but he stopped doing that in about 2015, and he became more interested in the law here in Nevada, particularly family law, because he had his own family court case at one point. And around this time, he begins working as a paralegal, and he also becomes the co-administrator of a Facebook group called Nevada Court Watchers. And this isn't some official organization or anything like that. It's just a Facebook site that's been created, and it's essentially just a web forum where anybody can go and they just talk about different things related to court cases here in Nevada, mostly here in Las Vegas. And they talk about any court cases, but there's an emphasis on family law, like mainly because a lot of these people are pro-per family court, so they ask for advice. Occasionally family lawyers in town will, as a public service, will just answer some questions, things like that. So that's what's going on in this group. And Mark As part of being co-administrator, he looks around online for things going on the news, things going on related to court cases here in Nevada. So he looks at videos and things on YouTube and other sites, and he sees what the defendant's doing. He sees these hearings, and he wants to know more. He wants to see if this is something he should post links to on Nevada Court Watchers. So he sends the defendant a Facebook message and says, hey, I heard about your case. Do you have any other videos of hearings that I can see? I'd like to take a look at it and see if people on Nevada Court Watchers would be interested. And the defendant gives Mark a link to his Google Drive, or specifically to a couple of folders in his Google Drive. And they contain not just video files, but there's audio files, there's a lot of documents related to his court case. It's quite voluminous, so Mark doesn't sift through everything when he first gets this link. He looks at some things, but he doesn't look at absolutely everything. And a few months go by, and Mark actually sees some YouTube videos that the defendant posts, which sound to him like audio recordings of telephone conversations. And then Mark takes a look at the Google Drive link, which is still active, and he checks out some audio files. And when he listens to them, he hears what sounds like recordings of 5 different phone conversations between the defendant and Candace. And he recognizes their voices because he's seen these family court hearings that the defendant has posted. So Mark sends Candace, the defendant's ex-wife, a message through Facebook, and then eventually he emails her the phone calls so she can listen to them, just so she can confirm what they are. And Candace, of course, she listens to them, and she recognizes them as conversations that she had with the defendant, Michael McDonald. And she recognizes them based on the content of the conversations. There are a lot of clues within the conversations indicating when these phone calls happened. They sort of indicate the progress of their daughter's gluten intolerance and how it led to a rectal prolapse and the status of their divorce and their custody situation. And most importantly, Candace had no idea that these conversations were being recorded. She had no idea. And she never, ever gave the defendant permission to record these telephone conversations. The defendant recorded these telephone conversations, these 5 separate telephone conversations, without Candace's consent. And that is why the defendant is charged with 5 counts of unlawful interception of wire communications. And I'm confident that at the conclusion of this case, you will find the defendant, Michael McDonald, guilty of all 5 counts. Thank you.
Thank you, Mr. Schler. Mr. Mueller, if you'd like to present your opening statement, you may proceed.
Thank you. Ladies and gentlemen, jury, if you were paying close attention, you saw that the state's case is as fishnet. We talked about feelings. We talked about divorces. We talked about communications. What you heard was 0 facts. A busybody, somebody who went out of his way to get involved in people's business he's got no relationship to, hacks a Google Drive account. He, that busybody, thinks that these are recordings. He then suggests to a venomous ex-wife that they are recordings, and therefore a crime has been committed. What you are not going to hear, and you're not going to hear, is anybody said, I recorded this. You're not going to hear the original recordings because all the documents the state's going to give you, the evidence will show, are edited so that they don't begin with opening statements like, hello, how are you? They don't end with, I don't want to talk to you ever again. No, you're going to hear just snippets of conversations, and they are auto-edited by people with malice. And what you're not going to hear at the close of statements is who actually recorded the statements. You're not going to hear when they were actually recorded. You're not going to hear any proof that they were, in fact, actually phone conversations. You're not going to hear the original documents, and you're going to hear from this busybody who's an expert in audio editing for his former job as a radio DJ. This case is not guilty. It requires evidence to convict somebody of a case, and the state will offer you nothing other than feelings and venomous bile from an ex-wife. At the end of the evidence, we're going to ask you to find Mr. McDonald not guilty of all accounts.
Thank you, Mr. Mueller. All right, the state, you may call your first witness.
State calls Mark Cicero.
Thank you.
statement already that you're allowed to ask questions, and so after the parties have questioned the witness, if you have any questions or you think of questions that you might want answered, write that down in your notebook. We can tear that off. Ultimately, I will confer with the parties before I ask any questions to determine whether or not they can be asked. There are some questions that can never be asked for reasons not allowed under the law, but I will make that determination. If your question is asked, you should not give it any extra weight. And if your question isn't asked, you aren't to speculate as to why it wasn't asked. It's just part of my decision as the judge to make certain rulings about what can and cannot be asked. Don't let me forget, if you have a question at the end, please raise that so the witness doesn't leave before that question is asked. Good morning.
Yes. You do solemnly
Me
swear the
too.
testimony about to give in this action shall be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Please be seated.
Thank you.
And then state and spell your name for the record.
First name Mark, M-A-R-K. Last name Cicero,
I never nag.
D-I-E-R-O.
Thank you. Mr. Romo, when you're ready.
Thank you. Mr. Sir, can I call you Mark?
You may.
Mark, what do you do for a living?
Currently, I am a law clerk and paralegal for a family law attorney in town. I also run my own paralegal business to help people in family court, draft pleadings, help with procedural issues. And I am also a radio personality, which I do part-time now. Used to do that full-time. So a few different things going on right now.
And which attorney do you work for?
Alex Gabato.
Does he practice family law?
He does.
You are a law clerk for him.
Correct.
Okay. And then you have your own business, which is a paralegal business?
That is right, yeah.
Is that separate and aside from your work with Mr. Gavato?
Completely separate, yes.
And you still do some part-time on-air radio personality work?
Correct.
For what radio station?
Most recently, Sunny 106.5, iHeartRadio. That wrapped up recently. May start back up again here in 2020. We'll see how, the schedule permits. It's just something I do now because I just really enjoy it. Something I love.
Okay. Have you previously had a more full-time role as a radio personality?
Yes.
In what context?
Let's see, from 1997 through about 2015, I was the host.
January 7th, 2020. They just heard. They all just got an inkling about what's about to hit them.
The Mark and Mercedes show for CBS Radio here in Las Vegas, and came from Colorado for that job. And like a lot of people, thought I'd be in Las Vegas for a couple years and move on, but 20 years went by in a heartbeat. So did that up until 2015.
Okay. And it seems like a big transition from being an on-air radio personality full-time to going to being a paralegal, working in a law office. What was the reason for the change?
I needed a lifestyle change. The sleep schedule was very problematic for me. I never, even after that long of doing morning radio, I never got used to getting up at 3 o'clock in the morning. Ended up taking medication to help with sleep. Ended up getting addicted to that medication. That medication took over my life. So it was time for a drastic change. Which is tough. So I, love radio, still do, but priorities and getting healthy and getting good was certainly more important at the time.
Okay. Are you speaking of Ambien?
Ambien, absolutely, yeah.
Now, are you familiar with a Facebook page called Nevada Court Watchers?
I am the co-administrator of Nevada Court Watchers.
How long have you been affiliated with that page?
Since 2017-ish, mid-2017, a couple of years, 2.5 years.
Is there anybody who administers that with you?
There is. Dave Shump is his name.
And did you guys create the page, or did you inherit from somebody else?
Dave came along later as far as an admin of the page. I took it over from somebody else. And that person, and I'm forgetting that person's name, that person really had lost interest in the page. When I became involved, it was there wasn't a whole lot of activity. and there were members, but there wasn't a lot of posting going on and whatnot. So to answer your question, yeah, I kind of inherited that page.
Okay. What kind of, just to give the jurors some kind of context for what this is, what exactly is Nevada Court Watchers?
So it's a Facebook page, and it's a page where we discuss family court litigation, child custody cases, divorce cases, cases that are of high interest, meaning that they're being talked about on other pages or in the community. Talk about attorneys, talk about litigants, talk about primarily family court cases, although it's not locked into just family court, but that would certainly be the bulk of what's discussed on Nevada Court Watchers.
Does the group have any actual meetups, or is it simply an online presence?
We have, on actually just one occasion, so more of just an online presence. Some of us know each other.
I might need more information like that, Dr. On Call.
Most of us just know each other through our online profiles and messaging each other online, that kind of thing.
Is this a paid group, or is it free?
No, it's free.
And so that, you've got a lot going on. You work as a paralegal for an attorney, you have your own paralegal group, you still do on-air radio things, and you're the co-administrator of this Facebook page, right?
Correct.
Why get out there and do that as well?
At the time, in 2017, well, to back up, I have a lot of involvement myself in family court. I divorced in 2005. Have a daughter who is now 16, almost 17, who's just my life, who I love more than anything in the world. And so I'm familiar with the high conflict litigation because my ex and I have been in that adversarial scenario at family court for a long time. So in 2017, things have been, calm for a long time, but we were back in some litigation. And that's where I first discovered a couple other pages on Facebook that were talking about cases. One was called The War Declared on Clark County Family Court. One page was run by a group called Veterans in Politics. They also talked about family court cases. So I just had an interest in this stuff, primarily because I was going through it myself. And I've always had an interest in law. I almost went to law school before I took a full-time job in radio. If I had not done radio for 20 years, I would have gone to law school and been a lawyer. So I've always had an interest in this stuff, but in 2017, because of my own case and what was happening, that interest was amplified, I guess, for lack of a better term.
Okay. Mark, I'm going to ask you a couple of questions about all that information you just gave us.
Okay.
Touched on a lot of subjects. But first, how many people would you say participate in this Nevada Court Watchers?
It's tough to say because the group, I think right now we're at 340 members in the group, but it's a public group, meaning anyone can view it. If you want to post into the group, you need to be a member, you need to join. But I know a lot of people check out the page on a regular basis that don't necessarily participate in it. But as far as active members, about 340.
Okay. And you mentioned having gone through a divorce in 2005?
Correct.
Okay, you say you have a daughter who's now 17, so you have one minor child?
Correct.
And when you divorced, there was custody issues, support issues, things like that?
Yes.
Okay. Was it a very hotly contested litigation, or did it all work out then?
Well, it's tough. I think it's worked out for my daughter, and that's the most important thing. That's all that counts. Yeah, it's worked out in the end, but these cases are tough. They're high conflict. And so there was definitely a custody battle. My goal and my efforts have always been joint physical custody, 50-50 custody. That's what I've exercised with my ex-wife from the beginning. We've had some hiccups along the way. But to answer your question, yeah, it's high conflict. We were only married for 2 years. We've been in court for 14, so that kind of says it all. But you'll do whatever you need to do for your child.
Okay. You mentioned a couple of other groups that piqued your interest. You mentioned something called War Declared on family court?
Correct.
What exactly is that?
So that's a page on Facebook. I think they also have a website. I think they also have a YouTube channel. It is run by the group Veterans in Politics, and their founder, Steve Sanson, is his name. And their goal is, well, their purported goal is to expose corruption in Clark County Family Court. So what happens when you, in trying to do that, they post.
I'm sorry, what was the objection?
There's no question.
Well, that's fine.
All right, you rephrase.
So does it have a forum? Can people come and discuss things in this Ward of Clare page?
Yes, it is set up very similar to Nevada Court Watchers.
Okay. And then you also mentioned Veterans in Politics International.
Correct.
What exactly is that?
Again, that's a group that says they're out to expose corruption. What happens when you look into that group is you find out that's where the corruption is.
Objection, there's no question.
Let's overrule who would answer your question.
All I can see is that 2 women got shot in a Philadelphia parade because they won the Super Bowl, and neither of them died. One was in the leg, and I don't remember where the other one was. But Philadelphia is Philadelphia. There was going to be riots and burning and everything, whether we won or lost the Super Bowl. Because Philadelphia is Philadelphia.
Now, do you know a man by the name of Michael McDonald?
Yes,
And do you see him seated in the courtroom today?
I do.
And where exactly would he be?
He's at the defendant table wearing a white shirt.
Does the record reflect identity?
The record will still reflect.
How did you come to meet this man?
Objection assumes facts, not evidence. Yes, that he knows him, not that he's met him.
Okay,
Oh,
that's fine.
That's overruled, you can rephrase your question.
Sure. When did you come to know him?
I came to know him in the middle of 2017, June or July of 2017. Mr. McDonald was discussing his divorce case on these 2 other pages, Veterans in Politics and the war declared on Clark County Family Court. He was talking about his case, the specifics of his case.
You heard the testimony.
Overruled.
He was talking about
You can continue on.
the specifics of his case. He was candidly slandering the judge that was overseeing his case.
And we approach.
You may approach.
Mark, if I could redirect us back to where we were going. You said that you became aware of who Michael McDonald was through his posts on Ward of Clare and Veterans in Politics?
Yes.
Okay. Any other forums, venues, websites?
You know, War Declared had its own, I believe War Declared had its own website, not just a Facebook presence, not 100% on that. Veterans in Politics definitely does have its own website, in addition to a Facebook presence. YouTube as well. Many of Mr. McDonald's hearing videos ended up being posted to YouTube by Mr. McDonald.
And how does that work? Are you familiar with YouTube?
Yes.
So, how does one post a video to YouTube?
Well, my understanding is, anybody can. You get an account, you open an account, set up your own page, upload the video of your choice or the videos, put a label on them, and they're out there for public consumption.
Do you need something called a channel to do that? Like a YouTube channel?
I believe you do.
Okay.
I believe you do. Veterans in Politics have...
There's no question.
That's no problem. And Mark, as you can see, considerable objections are coming from the defense. If you could just limit your answer to the question I'm asking, we'll probably prevent that from happening.
Okay.
Thank you. Why did you become interested in Mr. McDonald? He probably wasn't the only person posting, right?
That's correct.
Okay, so why Michael?
His case was, well, Michael was asking for input. He was asking strangers for input. What can I do in my case? I think he was either I think he'd either lost custody of his children or he was about to. He said, look, I've got a judge who is corrupt,
I have a judge who is biased against me.
Hearsay. Question is, why was he interested? Not what everything was told.
Your Honor, that's not hearsay, the defendant's statements.
The question was, why did he get interested?
But he's explaining why he got interested.
No.
That's overruled. That's overruled.
He became interested because those are pretty bold statements. When you say a judge is corrupt, a judge is biased. This judge and others are taking children away for no reason. Pretty salacious. It's attention grabbing, I think, by design.
Sure. No, I just want to make sure that we know, because you've been in the family court, correct?
Yes.
Since 2005?
Yes.
Is this the same judge that you were dealing with?
No.
So a completely different judge in family court, Mr. McDonald was griping about on an online forum or two?
Right.
Okay. And even though that wasn't the judge, did you have multiple judges over the time you were in family court?
I have, yeah. I've had 2 or 3 just because of department shuffling and that kind of thing, but I've never had involvement with the judge that oversaw his case.
Okay. So even though it wasn't a judge that you personally knew and had dealings with, the comments he was making piqued your interest?
Yes.
Okay. Did you have any kind of contact communication with Mr. McDonald?
I did.
And how did that come about?
I actually reached out to him, and this would have been July 2017. I reached out to him through Facebook Messenger. That's an app that allows you to text directly, to message directly. And so I actually asked Mr. McDonald for more info on his case because I was interested. Specifically, I wanted to know if he had
a narrative. He said he reached out for Facebook, which is an answer to the question.
Overruled. You can finish explaining his answer. You can finish. You can finish explaining.
I'll go ahead and hold.
Okay.
Sorry.
That's right.
May I report to it?
Okay.
Well, I'm showing you a document, it's a 2-page document that's stapled. It's marked State Exhibit 4, proposed. Could you take a look at that? Tell me if you're familiar with it.
Yes.
Okay. What is this document?
This is a copy of our exchanges, my communications with Mr. McDonald through Facebook Messenger.
Okay. Does this have to do with what you were just explaining about how you came to have contacts with Mr. McDonald?
Yes.
Okay. And is this an accurate copy of those communications?
Yes.
I move for admission of the state's proposal to the board.
Any objection?
No, if you lay its proper foundation. Is that fairly an accurate representation of the conversation? Then I have no objection.
Mr. Roman, do you want to ask that question?
I thought that was my last question.
You
But
just
it
asked
was
the
two.
question.
You want to ask that question again? You're free to.
Sure, I'd be happy to. That a fair and accurate depiction of a copy of the communications you had with Mr. McDonald.
For the second time it is.
No objection.
It will be admitted. As stated in the, I'm sorry,
This is number 4, Judge.
number 4. Thank you.
May I have your court clerk or reporter switch over to the document camera?
Yes.
Sorry for not prepping the certified.
That's okay. Ladies and gentlemen, we have technology in here, which is sometimes our friend and sometimes not. So bear with us as it can be finicky. Today, at least it seems to be working, which is good news. Bring it up. I think that's good.
No, is it? No, okay, I'll just ask another question.
If you don't mind asking the questions, we'll get this set up for you.
Sure.
Thank you.
So Bart, we'll come back to that once we get this way. We'll get into the actual words of the exchange when we have the document on the screen, but you said you reached out to Michael?
I did.
Okay. Was he receptive to you asking questions about the things he'd been posting about?
Yes,
Okay, did you guys engage in a dialogue?
we did.
Okay. At some point, did you request more materials, or did he offer more materials to you?
I requested more materials from him.
What were you seeking?
I wondered if he had more of his hearing videos.
Okay, so when you say more hearing videos, was there already hearing videos that you had seen?
Yes.
In what context had you seen these videos?
The same social media platforms we just discussed, Veterans in Politics, War Declared, YouTube. In fact, at that time, when I reached out to Mr. McDonald, he had just appeared on the Veterans in Politics talk show, which is a weekly internet show discussing the case in more detail. But the hearings were not being, what he was sharing was kind of cherry-picked, hand-picked, not in chronological order. So just said, hey, would you mind, do you have these videos, would you mind sharing them? And he did.
Do you have any knowledge on how you get videos of court proceedings?
I do.
And how is that?
You simply go down to the clerk's office at county court, you fill out a form, the video and transcript office, it's a copy for you on either a thumb drive or they used to do CD-ROMs, and I can do that anymore. It's very simple. Anything that is, any case that's not sealed, any case that's public record, you can get those hearing videos within a couple days.
Okay, and those are in computer file format, or are they like DVDs?
They are in Windows Media Video format, WMVs.
Okay, so you
I know that because I've got my own case.
Sure. So you know about this because you requested videos from your own hearings?
Yes.
Have you ever posted your own hearing videos?
No, absolutely no.
Okay. Is that a common occurrence that people will post on these forums?
Is it common? Yeah, but there is a theme.
Is that device reset at this point?
Try it again. If the light is blue, which gives me hope. No promises. Try hitting the blue button.
There we go.
There we go.
Perfect. Okay, publishing states Exhibit 4. I'm unfamiliar with Facebook, I don't have an account, so.
You don't have a Facebook account?
I do not.
Sometimes I wish I didn't have objection to questions.
I'm just giving context to my question.
That's it. That's the rules. We'll move on.
With regard to Facebook, there's a way to chat with people individually?
There is, through the Facebook Messenger app. You can do that on your desktop computer, you can do it on your phone. It's kind of a separate piece to Facebook. They run parallel together. It's just like a text message exchange or a direct message exchange through Instagram or Snapchat, similar.
Okay, and is that what you had with Mr. McDonald?
Yes.
Okay, I'm showing you the back page. Does this run chronologically from oldest to newest, back to front?
Back to front, yes.
Okay, so I'm showing you the back page of States Exhibit 4. I'll zoom in. Okay. Is this the first communication you had with Michael McDonald?
Yes.
So that appears to take place in July of 2017?
July 16th, 2017.
Okay. You've already explained when we were killing time before this equipment why you reached out to him. The next message on here, what is that?
You added Michael McDonald on Messenger. That is, I think that's similar when you send a friend request to somebody through Facebook, they have to accept it. There's some kind of protocol there. If you don't know the person, you have to reach out to them and they have to accept you as a quote-unquote friend.
Okay. And then similarly, the last one on this page, does that appear to be Michael adding you?
Yes.
Okay. So now that you guys are added on Messenger, you can communicate with each other?
Correct.
Going to the first page of State Exhibit 4. And it goes from bottom to top, right?
Yes, it does.
All right, so I guess just use this pen as a reference. Sorry, this one. What exactly is the context of this message from Michael to you?
Just to be clear, Mr. Rahman, let's get the timestamp to it, so we're looking at. It's timestamp 7:23 PM on July 16, 2017. What is the objection, Mr. Miller?
Always drop the rule.
Okay, you proceed.
So what's the context of him sending you a link?
Just that he was going to send me a link to some of his hearing videos. He sent me that link, or actually a series of links by email. So this message at 7:23 was followed up shortly thereafter by email, which you're not going to see here. 3 emails that are links to Google Drives that have hearing videos and so forth.
Okay, I'll show you that in a minute.
Okay.
Once we get through this document. Then there's communications from Michael. I'm pointing at something from 7:24 PM. Which you respond to. What is this dialogue here?
Mr. McDonald wants to know if I'm with the media, which I am, I was. He wants to invite me to an equal parenting rally in front of family court. There is so much corruption going along with that narrative of war declared and veterans in politics. I get then in the 7:28 PM exchange, I give him my email address, which is a Gmail account. Not presently in the media, used to host a morning radio show here in town. I'm always shocked at what happens in family court. Something needs to be done.
Okay. And then there's further dialogue on the top of this page, correct?
Yes.
Okay. And it looks like all of this, based on timestamps, take place on the very same day. This is all July 16th of 2017?
Yes.
Okay. So there's further dialogue, 7:28, 7:29, et cetera?
Yes.
Now, the last message at the top, the 7:29 from you to Michael. So, are you acknowledging you received the links?
I don't think I had received them yet. I said, if you're comfortable sharing the videos, I'd like to check them out. I don't think the email had come yet, but it was about to.
Okay. Then I'll show you what you were referencing earlier. There's a couple of exhibits got consolidated, some have done consolidated.
Okay. And I think actually you have the parties approach.
Sure.
So before we move on to the next exhibit, there was a question to see the last message exchange at the top of page 1. There's been no objection to showing that, so I'm going to ask the state to do that. If you could just, again, reference what exhibit it is and what you're showing.
Sure, put it on the document camera, States Exhibit 4, top of the document, first page. And this statement about my case has been crazy as well. Nowhere near the extent of yours. I've been in and out of family court for 12 years now. Is that you authoring that statement?
Yes.
Okay, so you're writing that to Michael?
Correct. And it looks like he responded with a thumbs up.
Any questions?
Yes, thank you.
Mark, I'm showing you what's been marked as State Proposed Exhibit 2.
Okay.
Are you familiar with these documents?
I am.
What are they?
These are emails from Mr. McDonald. Well, let me back up. Emails from me to Detective Colby Karchner. 7 of those emails. And then another email to the detective with a voluntary statement that I prepared. And exchanges with Detective Karchner.
This is the one.
Okay. Before we get into State's Proposed Exhibit 5, we're going to end on that today. I forgot to set up OJ, so I'm going to set that up. We'll do a little bit of OJ, and get ready for tomorrow, guys. Guys, get ready for tomorrow. Remember, tomorrow, I'm going to do a special live stream during the day. I was saying it's going to be around 1:30 Eastern Standard Time, p.m. 1:30 p.m. Eastern Standard Time. That's what time it's going to be, whether Court 5 has a docket or not. No, David. No, David. Denied. You have to be here. You have to be here. I looked, Kelly. I didn't see anything, so I gave up. I went to their website. I looked. I didn't find the information. I gave up. So it's still going to be tomorrow, around 1:30 p.m. Eastern Standard Time. Have a great day, guys. Thank you so much for coming out. We're almost to the end of this wild ride. Don't worry. Bye, guys.
Got these lights that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With extreme, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no